are not an appropriate substitute for evidence and have no place in your deliberations. And you should not consider anything that I've said or done during the trial, in ruling on motions or objections, in comments to the attorneys, or in setting forth the law in these instructions, as any indication of my opinion as to how you should decide this case. If you believe I've expressed or even hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or about what your verdict ought to be. That is solely and exclusively your duty and responsibility. In short, you're to confine your deliberations to the evidence and nothing but the evidence. As I explained at the beginning of the trial, the evidence consists of the testimony of the witnesses as you recall it, any documents or other things that were received into evidence as exhibits, and any fact on which the lawyers have agreed or which I told you you may accept as proved. You will have all of the exhibits with you in the jury room. You alone will decide the weight, that is, the value, that they deserve to receive in helping you to make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. And bear in mind, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. Rather, it is the weight of the evidence, its strength intending to prove the issue at stake that is important. For instance, you might find that a smaller number of witnesses, or even a single witness, who testifies to some particular fact are or is more believable than a larger number of witnesses who testify to the opposite. Now, some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question that was put to a witness is never evidence. Only the answers are evidence. Questions that made reference to facts or events that were not part of the evidence do not establish the truth of that fact or event unless the witness, in answering the question, adopts or agrees with the fact at issue. Finally, anything that you may have seen or heard when this court was not in session is not evidence. And during the trial, or the course of trial, certain evidence was admitted for a specific or limited purpose. On occasion, I gave an instruction at the time about the limited purpose for which that evidence was admitted, and you must follow those instructions during your deliberations. In particular, you've heard some evidence regarding alleged illicit drug activity or use by the defendant, Aaron Hernandez, and or others. You've heard evidence showing discord or hostility at times between the defendant and others, and testimony about the defendant's possession or alleged possession of a handgun at his home. As I instructed you earlier, such evidence may be considered by you only insofar as it explains the relationship between the defendant and Alexander Bradley, or to the extent you find it relevant on issues of motive, intent, opportunity, absence of mistake or accident, or on this defendant's state of mind. You may not consider this evidence as bearing in any way on the defendant's character or as any evidence of propensity to commit the crime charged or any other crime, nor as in any way affecting the presumption of innocence. Now, during trial, there was reference to a separate police investigation in June of 2013. That evidence was admitted solely insofar as it explained or was relevant to the police investigation in this case and for no other reason. You're not to speculate about the nature or outcome of any other matter. Indeed, you're not to consider or even discuss it during your deliberations. Rather, you are to discuss this case solely on the evidence you've heard in this courtroom and nothing else. The opening statements and the closing arguments of the lawyers are neither evidence nor a substitute for evidence. They are intended only to assist you in understanding the evidence and the contentions of the parties. If counsel stated something in their opening statement that was not developed by the evidence at trial, you are to disregard it, for you may decide this case based solely on the evidence presented. And my instructions and anything I've said in passing during the course of trial is not evidence. If your memory of the testimony differs from that as stated by the attorneys or from anything I may say, you're to follow your own recollection. Now, I permitted you to take notes during the testimony of the witnesses. Your notes are not evidence. They're not an official or even unofficial transcript of the testimony. And during deliberations, you're not to use your notes to attempt to persuade fellow jurors as to what the testimony was. Instead, you're to be guided by your memory of the testimony, and each juror's notes are personal to them and serve only to assist the note-taker in their recollection of the evidence. When you deliberate, it is your recollection of the testimony, to the extent assisted by your own notes, that determines what the evidence shows. During trial, you were taken on a view of certain areas, including the Cure Lounge at 246 Tremont Street in Boston, the Tufts Medical Center parking garage on Tremont Street, the intersection of Shawmut Avenue and Herald Street, and a police evidence storage facility where we viewed a Toyota 4Runner. The view was permitted to assist you in understanding and evaluating the evidence by reference to observations you made about the location and configuration of streets, businesses, and buildings, and surrounding features, including the location of surveillance cameras. The observations you made during the view may be used as evidence to the extent that the things observed during the view were in the same condition as they existed in July 2012. That is, with regard to the location and configuration of various streets, the location of buildings, surveillance camera positions, and the like. You may rely on your observations in assessing the evidence presented at trial. Now, the defendant, Mr. Hernandez, did not testify at this trial. As I informed you at the outset of this case, a defendant in a criminal case has an absolute right not to testify, established by our Constitution and in our statutes. The fact that the defendant did not testify is not evidence of anything, and you may not draw any adverse inference against this defendant because he did not testify. It's not a matter to be considered by you or even discussed during your deliberations. Rather, you must decide whether the Commonwealth has proved its case beyond a reasonable doubt based solely on the evidence you have heard and the reasonable inferences you draw therefrom. The fact that the defendant did not testify is absolutely not to be considered by you in your deliberations. Now, consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you have gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. Now, generally, there are two types of evidence that you can use to determine the facts of a case, and they're phrases I'm sure you've heard before. There's what's called direct evidence and circumstantial evidence. You have direct evidence where a witness testifies directly about some fact that is to be proved based on what he or she claims to have seen or heard or felt with their own senses. And the only question then is whether you believe that witness. You have circumstantial evidence where no witness can testify directly about a fact that is to be proved, but you're presented with evidence of other facts and then asked to draw reasonable inferences from them about a fact that is to be proved. Let me give you an example of the difference between direct and circumstantial evidence. Suppose that an issue to be decided is whether it's raining outside. And imagine as we sit here, the blinds are raised, and you're able to look out and see out the windows. And looking out the windows, you see clouds in the sky, you see water falling from the sky, you see puddles on the ground. That is direct evidence that it's raining outside. It's based on your personal observation, your sense of sight. Imagine, on the other hand, as we sit here, and as they are now, the blinds are closed. And imagine you cannot see directly the weather outside. But you recall that when you arrived here this morning, the sky was gray and threatening. And as you sit here, you see people entering the courtroom from the public door, coming in with wet clothing, shaking water off raincoats, closing umbrellas. That is circumstantial evidence that it's raining outside. You haven't seen it directly, but based on other observations you have made, you draw an inference or infer that it is raining outside by applying your common knowledge, your common experience, and your common sense to one set of facts, resulting in a conclusion of fact. You're entitled to consider both kinds of evidence. There is no difference in the probative value between direct and circumstantial evidence. And indeed, circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant guilty beyond a reasonable doubt from all the evidence in the case. Where the Commonwealth's case is based solely on circumstantial evidence, and that is for you to say, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty, a clear and settled belief that the defendant is guilty and that there is no other reasonable explanation for the facts as proven. The evidence and inferences you draw from the evidence must not only be consistent with the defendant's guilt, it must be inconsistent with his innocence. Now, an inference is a permissible deduction that you may make from evidence you have accepted as believable that leads to a conclusion, again, based on your experience, your common sense, and your general knowledge. For instance, when you see people entering a building with wet clothes or closing umbrellas, shaking water from them, you may draw an inference or infer that it's raining outside by applying your common knowledge and experience to a known fact, resulting in a conclusion of fact. You may draw an inference, even if it is not necessary or inescapable, so long as it or they are reasonable and warranted by the evidence you have found to be true. In order to draw an inference, the facts necessary to establish that inference must be proven beyond a reasonable doubt, and you may not use conjecture or guesswork in drawing inferences. An inference that is merely possible is not acceptable. It must be possible and reasonable and based on evidence that you have accepted as true. In order to convict the defendant, you must find that all the evidence and the reasonable inferences taken together and that you have drawn prove that he is guilty beyond a reasonable doubt. If it does not, you must acquit him. Now, during the trial of this case, the attorneys have introduced over 380 items as exhibits. And these include photographs, cell phone records, records relating to cell tower locations, surveillance videos, still photos, and still photographs from videos, some clothing, hospital records, 2 death certificates, a purported firearm and ammunition, other ballistics evidence, and other items. Exhibits are one form of evidence offered to assist you during your deliberations. Exhibits are those items that are marked with a numbered exhibit tag, as distinguished from other items, blow-ups or charts that served as demonstrative aids and were given a letter designation for identification. These items, which were referenced or shown during the trial, will not be available to you during deliberations because they were not formally received into evidence as exhibits. But as to the exhibits with numbered tags, you will have all of those items available to you during deliberations, so you may examine them to whatever extent you wish. With regard to physical items that are within evidence bags, please exercise caution in handling those items. Our court officers will provide you with latex gloves for your use in handling these items during deliberations. And a number of the exhibits in this case are in electronic form, either on thumb drives or CDs or discs. If you're unable to access any exhibit electronically, please send me a note and we'll attempt to correct the technological problem. Now, as with the testimony of witnesses, you may give exhibits whatever weight or value that they deserve in helping you to make your ultimate judgment about whether the Commonwealth has proved its case against this defendant, Aaron Hernandez. You're not required to believe something simply because it's written on a piece of paper or appears in a photograph. You're not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give each exhibit. Now, several photographs were introduced during the trial that may be considered upsetting, disturbing, or graphic, showing the location of apparent injuries to each of the decedents. These photographs were admitted into evidence to assist you in determining the facts of the case, but you cannot be influenced by any sympathy, sorrow, or pity, nor by anger or outrage. You may consider such evidence only to the extent it helps you to understand and determine the facts, but you must be dispassionate and rational in assessing whether the Commonwealth has met its burden of proof. Now, it will be your duty to decide any disputed questions of fact. You will have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it is your function to resolve those conflicts and to determine where the truth lies. You may believe everything that a witness says, or only part of it, or none of it. If you do not believe a witness's testimony that something happened, of course your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means you have to look elsewhere in the evidence for credible evidence about that issue. Now, in evaluating the credibility of a witness, you may use various tools. You may consider the ability, the opportunity, and the reliability of a witness to see or hear something in the past and then remember and later testify before you in this courtroom. You may consider the appearance of a witness while testifying before you. Any inconsistency you may have found in the witness's testimony, the witness's conduct while testifying before you, and whether the witness's ability to perceive, remember, or relate events was affected by the ingestion of drugs or alcohol. You may consider if the witness has any interest in the outcome of these proceedings and any bias or prejudice or hostility that may have been demonstrated by the witness while testifying before you, the level of accuracy of the witness while testifying before you, and the reliability of their testimony as it developed before you, the members of this jury. Now, one witness, Alexander Bradley, testified under a cooperation agreement with the Commonwealth, where, in exchange for his truthful testimony, he would not be prosecuted. Where a witness testifies pursuant to an agreement that provides a benefit to the witness, you should examine that witness's testimony with great care and caution. In addition to all the other factors I've mentioned bearing on credibility, you should consider whether the witness's testimony has been affected by his interest in the outcome of the case and any benefit that he has received or hopes to receive in the future. You should also consider the fact that the Commonwealth does not know whether the witness is telling the truth in his testimony. That is a determination only you can make. Similarly, a number of witnesses, including Alexander Bradley, testified under grants of immunity from prosecution. These witnesses also included Cheyenne Jenkins Hernandez, Tyrone Crawford, Jarrell Pierre, and Oscar Hernandez. Where a witness testifies under a grant of immunity, you should examine that witness's testimony with great care and caution. Under Massachusetts law, a defendant cannot be convicted based solely on the testimony of an immunized witness. There must be some corroboration of that witness's testimony as to at least one essential element of the crime or crimes charged. Now, recall what I said and instructed at the outset of this case, that all witnesses are to be treated equally and the same in terms of your assessment of their credibility and their testimony. The fact that a witness is a police officer or associated with law enforcement does not mean, standing alone, that his or her testimony is more or less credible than any other witness. Now, during the course trial, counsel have questioned some witnesses about prior statements that they made to the police or others outside of court. In evaluating a witness's testimony in court, you may consider whether that witness made any earlier statement that differs from or contradicts in any way his or her in-court testimony, and we call these prior inconsistent statements. To qualify as inconsistent, it's not necessary that the prior statement contradict in plain terms the testimony of the witness. It is enough that the statement taken as a whole, whether by what it says or by what it omits to say, affords some indication that the fact was different from the testimony of the witness. The earlier statement is admitted into evidence solely for your consideration in evaluating the witness's credibility. As to prior unsworn statements, you may not consider the earlier statement as evidence or proof of the truth of any fact contained in that earlier statement. And if a witness has been impeached by a prior inconsistent statement, give the testimony of such witness or that witness such weight as you see fit. Keep in mind that an innocent misrecollection, like a failure of recollection, is not an uncommon experience. In weighing the effect of any discrepancy in a witness's testimony, consider whether it pertains to a matter of importance or an unimportant detail, and whether you feel that discrepancy results from an innocent error or whether the witness has intentionally and purposely given false testimony. And a similar rule applies with regard to any prior statements that were consistent with the witness's in-court testimony. If a witness is impeached by a prior statements that are inconsistent with their in-court testimony, you may consider the fact that the witness gave an earlier or prior statement consistent with their testimony in court to rebut a claim that the witness's testimony is a recent contrivance or a fabrication, or is motivated by some promise or hope of reward or inducement. Again, that earlier statement is not admitted as substantive proof of the truth of any fact contained in that earlier statement. Now, certain witnesses were questioned about prior testimony they provided at a grand jury proceeding, and their grand jury testimony was presented as substantive evidence, that is, for the truth of what they said under oath at the grand jury. In these instances, you may consider the witness's prior grand jury testimony for all purposes, that is, not only in showing a prior inconsistent or a consistent statement, but for the truth of what was said as well. Finally, there was a portion of a recorded police interview with Rashidis Gomes Sanchez that was played regarding Mr. Sanchez's description of the shooter. Although that was a prior statement, it was admitted as substantive evidence and may be considered by you for all purposes. There's one more point about witnesses to address, and this relates to so-called expert witnesses. This term refers to witnesses who have some specialized training or experience in a given field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their personal knowledge, that is, things that they've personally seen or heard or felt. However, in a variety of cases, issues arise that are beyond the experience of laypersons, and in those types of cases, we allow a person with some specialized training or experience, called an expert witness, to testify, and to testify not only to facts, but also to opinions and reasons for their opinions on issues that are within that witness's field of expertise and that are relevant material to the case. In this case, a number of witnesses have testified to things that they did or reviewed based on some professed specialized knowledge or expertise. These include a medical examiner, Dr. Catherine Lindstrom, who testified to the autopsy she conducted and opinions formed regarding the cause and manner of the deaths of Daniel De Abreu and Safiro Furtado. Dr. Jamie Downs, a forensic pathologist, who reviewed materials and gave opinions regarding the circumstances surrounding the deaths of Mr. De Abreu and Mr. Furtado, and offered opinions regarding the number and paths of travel of gunshots. We heard from Thomas Murphy and Detective Tyrone Camper, who testified to their respective examinations of a .38 caliber revolver and ammunition, and offered opinions regarding that handgun and ammunition, and in addition, as to Detective Camper, offered opinions about his examination and comparison of bullets or shell casings with ammunition test-fired from the .38 caliber revolver that has been introduced as an exhibit. You also heard from various witnesses who examined cellular telephone records and data recorded in those records, or conducted forensic examinations of cellular telephones and a laptop computer. These witnesses included Sergeant Kevin Witherspoon, ATF Special Agent Matthew Kelsch, Senior Marshal and Senior Inspector of the U.S. Marshal Service, Anthony Vasali, Sergeant Timothy Latham, and Jacob Green, all of whom testified based on some professed specialized knowledge and training. You heard from various chemists and analysts from crime laboratories who testified regarding scientific testing they conducted and the results of that testing, to include John Biello, who spoke about gunshot residue testing, Stephen Lord, who testified about fingerprints, both from the Massachusetts State Police Crime Laboratory. And you heard from Kristen Tolan, Amy Reynolds, and Julie James, all of the Boston Police Crime Laboratory, who testified about forensic examinations for fingerprints, DNA, and trace evidence. And you heard from Michael Haig, who testified and offered opinions regarding the number of shots fired and the likely path of travel of bullets. Now, because a particular witness has some specialized training and experience in his or her field, does not put that witness on any higher level than any other witness, and you're to treat expert witnesses just like you treat all other witnesses. In other words, as with any other witness, it is completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that witness gave. It is also entirely up to you to decide whether you accept the facts relied upon by the expert and to determine what conclusions, if any, you draw from that expert's testimony. You're free to reject the testimony and opinion of such a witness in whole or in part if you determine the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. Now, on occasion, an expert witness may be asked to render an opinion based on assumed or hypothetical facts, and in those instances, the opinion rests on the truth of the assumed or hypothetical fact. In order to accept an expert's opinion under these circumstances, the facts that were assumed must be part of the evidence and accepted by you as true. Put another way, if an expert witness rendered an opinion based on assumed facts that you do not find to be true, then you should reject the opinion to the extent it relies on those assumed facts or on facts contrary to those found by you, the jury. Keep firmly in mind that you alone decide what the facts are, and if you conclude an expert's opinion is not based on the facts as you find those facts to be, then you must reject that testimony and opinion of the expert in whole or in part. And any expert's opinion cannot be purely subjective. Rather, it must be expressed as held, quote, to a reasonable degree of professional certainty in the particular field of expertise, for instance, ballistics, medicine, or some other science. Now, you must remember that expert witnesses do not decide cases. Juries do. In the last analysis, an expert witness is like any other witness, in the sense that you alone make the judgment about how much credibility and weight you give an expert's testimony and what conclusions you draw from that testimony. Now, during the trial, one or more of the Commonwealth's witnesses was questioned regarding scientific testing that was or was not performed, or investigative activity that was or was not performed. A failure on the part of the Commonwealth to conduct some scientific tests or otherwise follow standard procedure during a police investigation is a factor you may consider in evaluating the evidence presented in this case and whether the Commonwealth has met its burden of proof. With regard to this factor, you should consider three questions. First, whether the omitted tests or other actions were a standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the tests or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality or reliability of the evidence presented by the Commonwealth. Alternatively, you may consider whether the omissions tend to show the existence of some police bias against the defendant in conducting the investigation. All of these considerations involve factual determinations and are entirely up to you, and you're free to give this matter whatever weight, if any, you deem appropriate under all the circumstances. Now, a defendant in a criminal case has a constitutional right to present evidence that another person may have committed the crime. Thus, a defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity to commit it. In this case, the defendant contends that Alexander Bradley committed the crimes charged relating to the Boston shooting incident. And this is referred to under the law as third-party culprit evidence. Such evidence must be relevant and have a rational tendency to prove the third-party culprit defense that the defendant raises, and the evidence cannot be too remote or speculative. Moreover, the Commonwealth does not have the burden of proving that no one else committed this crime. It is the Commonwealth's burden to prove beyond a reasonable doubt that this defendant committed the crime. However, you may consider evidence that another person committed or may have committed these crimes in determining whether the Commonwealth has proved its case against this defendant beyond a reasonable doubt. Now, some evidence was presented regarding the defendant's activities or conduct after July 16, 2012, to include garaging the Toyota 4Runner at 114 Lake Avenue in Bristol, Connecticut, and disposing of certain items. Evidence was presented that after February 13, 2013, the defendant changed his cellular phone and spoke with Brooke Wilcoxon several times. Finally, evidence was presented that at some point the defendant obtained tattoos in California in 2013. If the Commonwealth has proved that the defendant acted in one or more of these ways, you may consider whether such actions indicate feelings of guilt by the defendant, and whether, in turn, such feelings of guilt might tend to show actual guilt on these charges. You're not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of the case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. But you should always bear in mind and remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. And please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. On the issue of the defendants obtaining various tattoos, please recall the instruction I gave at the time this evidence was admitted, that you may not consider such evidence as demonstrating anything about the defendant's propensity to commit crime generally or to engage in gun violence, nor as any evidence reflecting negatively on the defendant's character. Now, in the instructions regarding the specific crimes, I will refer on occasion to the defendant's intent, which must be proved as part of the element, as part of one of the elements of the offense charged. Intent refers to what a person's objective or purpose is. It is to be determined by you, the jury, from all the evidence and the circumstances developed at trial. Intent is a fact which may or may not be susceptible of proof by direct evidence. If it is not susceptible to proof by direct evidence, resort may be taken by you as finders of fact to reasonable inferences drawn from all the facts as you have found them. And there are two types of intent under the law. There is general intent and specific intent. A general intent is when we do things more or less routinely as a matter of reflex, such as sitting down in a chair or walking upstairs. Those are actions done with a general intent. We would not do them unless our mind resolved to do them, but they don't require any concentration or focusing of the mind. Specific intent, which must be proved here, is the act of concentrating or focusing the mind for some perceptible period. It is a conscious act with the determination of the mind to do the act. It is contemplation rather than reflex, and it must precede the act. Therefore, in the instructions to follow, when I refer to the defendant's intent to kill, or to cause grievous bodily harm, or to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, I'm referring to proof of specific intent, and the Commonwealth must prove the defendant acted as the result of some contemplation and thought, and not as the result of any routine or reflex. Now, one of the most important issues in this case is the identity of the person who committed the crimes. The Commonwealth alleges, and therefore must prove beyond a reasonable doubt, that this defendant was in fact the perpetrator of the crime alleged in the indictment. If you are not convinced beyond a reasonable doubt that the defendant is the person who committed the crimes charged, then you must find the defendant not guilty. Now, identity may be proved by direct evidence, by circumstantial or indirect evidence, and the reasonable inferences flowing therefrom, or by some combination of direct and circumstantial evidence, but it must be proved, as I said, beyond a reasonable doubt. Now, in evaluating the testimony of any witness who either identified the defendant or provided a description of the offender, it is not essential that a witness be free from doubt as to the correctness of his or her identification or description. However, you, the jury, must be satisfied beyond a reasonable doubt, based on all the credible evidence, that this defendant is the person who committed the crime before you may convict him. As with any witness, you must determine the credibility of a witness identifying or describing the defendant. If you conclude that a witness is not telling the truth regarding an identification or description, you shall disregard that testimony. If you conclude that a witness intended to tell the truth, you should still consider the possibility that the witness may have made a good faith error in their identification or description. That is, you should consider whether a witness could be honestly mistaken in his or her identification or description of the defendant or of an offender. Now, understand, human beings have the ability to recognize other people from past experiences and to identify or describe them at a later time, but research and experience have shown that people sometimes make mistakes in identification. Research has focused on the factors that may affect the accuracy of an identification, including the nature of human memory. As I think one of the counsel told you, I would be saying in my instructions, with regard to memory, the mind does not work like a video recorder. A person cannot just replay a mental recording to remember what happened. Memory and perception are much more complicated. Remembering something requires 3 steps. First, a person sees an event. Second, the person's mind stores information about that event. And third, the person recalls stored information. At each of these stages, a variety of factors may affect or even alter someone's memory of what happened, and thereby affect the accuracy of their memory or testimony. Indeed, this can happen without the witness even being aware of it. I'm going to list some factors that you should consider in determining whether any identification or description testimony is accurate. And in doing so, I'm not expressing any opinion about the accuracy of any specific memory of any particular witness. You, the jury, must decide whether any witness's identification or description is accurate. Among the factors to be considered are, first, you should consider the opportunity the witness had to observe the person about which they provided an identification or description. For example, how good a look did the witness get of the person and for how long? How much attention was the witness paying at the time? How far apart was the witness from that person? How good were the lighting conditions? Did they observe the person only once or on multiple occasions? You should evaluate a witness's testimony about his or her opportunity to observe with care. You should consider whether a witness saw a weapon during an event. If the event is of short duration, the visible presence of a weapon may distract the witness's attention away from the person's face or features. But the longer the event, the more time the witness may have to get used to the presence of a weapon and focus on the person's face or features. You should also consider whether the person observed had any distinctive features or characteristics. You should consider the physical and mental characteristics of the witness when they made observations. For example, how good was the witness's eyesight? Was the witness experiencing any illness, injury, or fatigue, or under the influence of any drugs or alcohol? Or was the witness alert and focused? Was the witness under a high degree of stress? High levels of stress may reduce a person's ability to make an accurate identification. You should consider whether the witness and the offender are of different races or ethnicities. If a witness and the person identified appear to be of different races or ethnicities, you should consider that persons may have greater difficulty in accurately identifying someone of a different race or ethnicity than someone of their own race or ethnicity. You should consider how much time passed between the event observed and the description or identification given to the police. Generally, memory is most accurate immediately after an event and begins to fade soon thereafter. You may consider a witness's identification or description even where the witness is not free from doubt regarding its accuracy. But you should also consider that a witness's expressed certainty in the accuracy of their identification or description, standing alone, may not be a reliable indicator of the accuracy of that identification or description, especially where the witness did not describe the level of certainty when the witness first gave that description or made an identification. And you should consider the accuracy of a witness's identification or description and the fact that it could be affected by information the witness received between the event they observed and the time they gave that description or made an identification, or information received after they have done so. Such information may include descriptions given by other witnesses, or photographs or media accounts, or any other information that may affect the independence or accuracy of the witness's identification or description. Exposure to such information may not only affect the accuracy of the information provided by the witness, but may also affect the witness's expressed level of certainty and the witness's memory about the quality of his or her opportunity to view the event. The witness may not realize that his or her memory has been affected by such information. An identification made after suggestive conduct by the police or others should be scrutinized with great care. And if an identification occurs after or through an identification procedure conducted by the police, which involves the showing to a witness of a photograph or set of photographs, you should consider whether the witness identified the defendant under such circumstances. Consider all of the factors I have already described about a witness's perception and memory. You should also consider the number of photographs shown and whether anything about the defendant's photograph made him stand out, whether the person showing the photograph knew who the suspect was or could have been, and whether the person showing the photograph could have, even inadvertently, influenced the identification. You should consider that an identification made by picking someone out of a group of similar individuals is generally less suggestive than one that results from the presentation of a single photograph. You should also consider whether the police, in showing a photograph, followed protocols or policies of their police department in conducting an identification procedure that are designed to diminish the risk of suggestion. If protocols were not followed, you should evaluate the identification with particular care and consider whether the failure to follow the protocol affected the reliability of the identification. And you should consider whether a witness ever failed to identify the defendant or the offender, or made any identification that was inconsistent with the identification that the witness made at trial. In evaluating the accuracy of a witness's description or identification, you should consider all of the relevant factors that I've discussed in the context of the totality of the evidence in this case. Specifically, you should consider whether there is other evidence in this case that tends to support or cast doubt on the accuracy of a witness's identification or description. As I instructed earlier, if you are not convinced beyond a reasonable doubt that the defendant is the person who committed this crime, you must find him not guilty. Now, the defendant in this case, as in any criminal case, is presumed to be innocent. And you, the jury, must bear in mind that the law never imposes on a defendant in a criminal case the burden or duty of calling any witness, or indeed of presenting any evidence whatsoever. And this legal presumption of a defendant's innocence is not an idle theory to be discarded or disposed of by you, the jury, by caprice, passion, or prejudice. And furthermore, a defendant is not to be found guilty on any of these indictments on suspicion or conjecture, but only on evidence produced and admitted before you in this courtroom. The fact that the defendant may have been arrested, held in custody, or complained against is not to be regarded as a circumstance tending to incriminate the defendant or creating any unfavorable impression against him. And understand, an indictment is not evidence. The indictment is nothing more than the piece of paper we use in our system to bring the defendant before the court and inform the defendant of the charges that have been made against him. The defendant is presumed to be innocent until and unless you, the jury, decide unanimously that the Commonwealth has proved the defendant guilty of each and every element of the charged offense or offenses beyond a reasonable doubt. In this case, as in every criminal case, the burden of proof is on the Commonwealth, and the Commonwealth has the burden throughout the entire trial. A defendant never has any burden to prove his or her innocence or produce evidence. There is no duty resting on a defendant to prove or otherwise establish his or her innocence. The Commonwealth must prove each and every element of every charged offense beyond a reasonable doubt, and if from the evidence introduced before you, you members of the jury entertain a reasonable doubt as to whether or not the defendant committed the crimes with which he is charged, then you must find the defendant not guilty. Now, the burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not so easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. And when we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt, again, to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. And this is what we mean by proof beyond a reasonable doubt. Now that completes the first and longest portion of my instructions. Why don't we all stand and take a short stretch break? You too. Now, as I turn to the second portion of my instructions, I'm going to have handed out a chalk. Do you have that, Mr. Sheehan? Well, unless you want to send him his paper airplanes. All right, ladies and gentlemen, let me depart from the written instructions for just a moment to say that what you've just received is what's called a chalk, setting forth the requirements, that is, the elements of each of the 8 separate offenses. So it is to be considered as an outline. It is not a substitute for the full instructions that I will give you, because many of the elements and the terms used in the chart have a specific and particular meaning under the law. So please use that as a guide, but don't let that distract you from listening to the instructions I now give as to the particular charges in this case. Let me turn now to the law as it relates specifically to this case. The defendant is charged with 8 separate offenses. 7 of the charges relate to the events of July 16, 2012. They are 2 counts of murder relating to the deaths of Daniel De Abreu and Safiro Furtado, 3 counts of armed assault with intent to murder relating to the 3 other occupants of the BMW, that is Aquilino Freire, Gerson Lopes, and Rachides Gomes Sanchez. A charge of assault and battery by means of a dangerous weapon relating to the shooting of Aquilino Freire, and unlawful possession of a firearm. The 8th charge is for witness intimidation, so-called, relating to the shooting of Alexander Bradley in Florida on February 13, 2013. Through your deliberations, you must determine whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of any or all of these charges. And you must treat each charge separately, and your verdict as to each charge must be unanimous, although it need not be the same verdict on all charges. Now, as it relates to the 7 charges arising out of the events of July 16, 2012, the Commonwealth has alleged, and therefore must prove, that the defendant personally committed these crimes. It is not sufficient to show that the defendant was merely present when such crimes occurred, nor would it be sufficient to show that the defendant acted in some way, or that the defendant in some way concealed evidence of these crimes after the fact. Now let me start with the crime of murder. Murder is the unlawful killing of a human being. An unlawful killing is a killing done without excuse. Not all killings are unlawful. A killing may be excused, for example, in the case of self-defense or defense of another, or in some cases, accident. The evidence in this case does not raise the issue of whether these killings were excused as the result of accident, self-defense, or defense of another. The burden of proof is on the Commonwealth to prove beyond a reasonable doubt that the defendant, Mr. Hernandez, unlawfully killed Daniel De Abreu and Safiro Furtado. And there are 2 different degrees of murder. Murder in the 1st degree and murder in the 2nd degree. The degree of murder shall be found by you, the jury. Through your deliberations, you must determine unanimously if the Commonwealth has proven beyond a reasonable doubt that the defendant that the defendant is guilty of murder in the 1st degree, and if not, whether he is guilty of murder in the 2nd degree. You have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proven beyond a reasonable doubt, which, in the case of murder, is murder in the 1st degree. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of either murder in the 1st or 2nd degree, then your verdict as to these counts must be not guilty. Now let me explain what constitutes murder in the 1st and 2nd degree, focusing first on murder in the 1st degree and then murder in the 2nd degree. And in defining the elements of murder in the 1st and 2nd degree, it must be noted that the Commonwealth does not have to prove that the defendant had any particular motive for these killings. In other words, motive is not an element, or one of the elements, the Commonwealth must prove beyond a reasonable doubt. However, you may consider any evidence that you've heard relative to a particular motive for the killing in considering whether the Commonwealth has proved the defendant's guilt. Now, turning to 1st-degree murder. As applicable here, an unlawful killing is murder in the 1st degree if it was committed with deliberate premeditation or was committed with extreme atrocity or cruelty. Here, the Commonwealth alleges that the defendant acted with deliberate premeditation in the deaths of Daniel De Abreu and Safiro Furtado, and as to Mr. De Abreu, that his death is also 1st-degree murder based on extreme atrocity or cruelty. Therefore, as to the deaths of both men, you must determine whether the Commonwealth has proved the defendant guilty of first-degree murder based on deliberate premeditation. And additionally, as to Daniel De Abreu, whether the Commonwealth has proved the defendant guilty of first-degree murder based on extreme atrocity or cruelty. Now let me review each of these two theories in turn. Turning first to deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. First, the defendant caused the deaths of Daniel De Abreu and Safiro Furtado. Second, that the defendant intended to kill Daniel De Abreu and or Safiro Furtado, that is, he consciously and purposefully intended to cause the deaths of both men. Third, that the defendant committed the killings with deliberate premeditation. That is, he decided to kill after a period of reflection. Let me review each of these elements in more detail. The first element is that the defendant caused the deaths of Daniel De Abreu and Safiro Furtado. A defendant's act is the cause of another's death, where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant specifically intended to kill Daniel De Abreu and or Safiro Furtado. That is, he consciously and purposefully intended to cause their deaths. As a general rule, you are permitted, although not required, to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm. And a dangerous weapon is any item or object that by its design or by the manner of its use is capable of causing death or serious bodily harm. And I instruct you that a firearm is a dangerous weapon under our law. And the third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that the defendant takes no time to reflect on the action and then decides to do it. And when deciding whether the defendant intended to kill a victim and whether he formed the intent with deliberate premeditation, you may consider any credible evidence that the defendant was in some way affected by his consumption of alcohol or drugs. A defendant may form the required intent and act with deliberate premeditation, even if he consumed alcohol or drugs, but you may consider such evidence in determining whether the Commonwealth has proved these elements. In determining whether the Commonwealth has proved the second and third elements, that is, that the defendant intended to cause death and did so with deliberate premeditation, remember my earlier instruction on intent and specific intent. Now, the second theory of murder in the first degree is murder committed with extreme atrocity or cruelty. And this instruction applies only to the indictment regarding Daniel De Abreu. You shall consider this theory of murder in the first degree regardless of whether you find the Commonwealth has proved murder in the first degree with deliberate premeditation. That is, you should consider both theories of first degree as it relates to the indictment pertaining to the death of Mr. De Abreu. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Daniel De Abreu. 2, that the defendant either intended to kill Daniel De Abreu or intended to cause him grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And last, that the killing was committed with extreme atrocity or cruelty. Let me discuss each of these elements in more detail. The first element is that the defendant caused the death of Daniel De Abreu, and again, a defendant's act is the cause of another's death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant either intended to kill Mr. De Abreu, intended to cause him grievous bodily harm, or intended to do an act which, again in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And as to this element, the second element, it has 3 sub-elements which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant specifically intended to cause grievous bodily harm to Daniel De Abreu. And serious grievous bodily harm means severe injury to the body. And the third prong is that the defendant specifically intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And let me help you to understand and analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, then you must determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances as known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Again, in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by his consumption of alcohol or drugs. Now, the third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act which is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of human life. You must determine whether the method or mode of a killing is so shocking as to amount to murder with extreme atrocity or cruelty. And the inquiry focuses on the defendant's action in terms of the manner and means of inflicting death and on the resulting effect on the victim. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of Miss De Abreu with extreme atrocity or cruelty, you must consider the following factors. First, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. Second, the consciousness and degree of suffering of the deceased. Third, the extent of injuries to the deceased. Fourth, the number of blows delivered. Fifth, the manner, degree, and severity of the force used. Sixth, the nature of the weapon, instrument, or method used. And finally, the disproportion between the means needed to cause death and those employed. And this seventh factor refers to whether the means used were excessive or out of proportion to what would be needed to kill a person. You cannot make a finding of extreme atrocity or cruelty unless it's based on one or more of the 7 factors I've just listed. And in considering these factors, you may consider the defendant's mental condition at the time of the killings, including any credible evidence about the effect on the defendant of his consumption of alcohol or drugs, in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed this killing with extreme atrocity or cruelty. Now, if after considering all the evidence, you conclude that the Commonwealth has proved beyond a reasonable doubt each of the elements as I've defined them for murder with deliberate premeditation, or separately as to Mr. De Abreu for murder by extreme atrocity or cruelty, or both, then you should find the defendant guilty of murder in the first degree. However, if after considering all the evidence in this case, you are not satisfied that the Commonwealth has proved beyond a reasonable doubt the elements of murder in the first degree on either theory of deliberate premeditation as to both, and the additional theory of extreme atrocity or cruelty as to Mr. De Abreu, then you must not find the defendant guilty of murder in the first degree, and you must consider whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of murder in the second degree. To prove the defendant guilty of murder in the second degree, the Commonwealth must prove the following elements beyond a reasonable doubt. First, the defendant caused the deaths of Daniel De Abreu and or Safiro Furtado. And second, that the defendant either intended to kill Daniel De Abreu and or Safiro Furtado, or intended to cause grievous bodily harm to the named victim, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Now, the requirements for proof of murder in the second degree are the same as the elements of murder in the first degree with extreme atrocity or cruelty, but without the element that the murder was committed with extreme atrocity or cruelty. Therefore, all the instructions that I've given you regarding the elements of murder in the first degree under a theory of extreme atrocity or cruelty fully apply here as well, with the exception that to prove second-degree murder, the Commonwealth need not prove that the death occurred with extreme atrocity or cruelty. Now, if after considering all the evidence in this case, you conclude that the Commonwealth has not proved murder in the first degree, but has proved beyond a reasonable doubt each of the elements for murder in the second degree as I've defined them, then you should find the defendant guilty of murder in the second degree. If, however, after considering all the evidence in this case, you are not satisfied that the Commonwealth has proved beyond a reasonable doubt any one of these elements as I've defined them, then you must find the defendant not guilty on the counts of murder. Now, in this case, the defendant is charged with 3 counts of assault with intent to murder while armed with a firearm. And these relate to alleged assaults on Aquilino Ferrier in count 3, Gerson Lopes in count 4, and Rashides Gomes Sanchez in count 5. In order to prove armed assault with intent to murder, the Commonwealth must prove 3 elements beyond a reasonable doubt. First, that the defendant assaulted the person named in that particular count. Second, that the defendant possessed a specific intent to cause the death of the person assaulted. And third, that the defendant committed the alleged assault by means of a dangerous weapon. Now, the first element the Commonwealth must prove beyond a reasonable doubt is that the defendant assaulted the alleged or named victim. An assault may be committed in one of 2 ways. First, assault is defined as an attempt or offer by one person to do bodily injury to another by force and violence. Alternately, an assault may consist of putting a person in fear of immediate bodily injury. You may find the defendant guilty only if you all unanimously agree that the Commonwealth has proved beyond a reasonable doubt that the defendant committed an assault in one of those 2 ways. Now, the first type of assault consists of an offer or attempt to commit a battery. In this type of assault, the Commonwealth must prove beyond a reasonable doubt that the defendant intended to physically harm the alleged victim. The Commonwealth must also prove that the defendant did an act towards the commission of inflicting physical harm on the alleged victim. In other words, the Commonwealth must show the defendant did in fact attempt to do bodily harm on the alleged or named victim. And finally, the Commonwealth must prove the defendant had the actual or apparent ability to inflict bodily harm. This means that the Commonwealth need not show the defendant possessed the actual ability to do bodily harm. Apparent ability will suffice. However, the Commonwealth does not have to show that the alleged victim was apprehensive or fearful. Fear or apprehension on the part of another is not an essential ingredient of this type of assault. And the second type of assault occurs when the defendant, with the intent to cause apprehension of immediate bodily harm, does some act that causes such apprehension. First, the Commonwealth must prove beyond a reasonable doubt that the defendant possessed the intention to cause apprehension of immediate bodily harm. Second, the Commonwealth must show the defendant engaged in conduct of the sort that would raise reasonable apprehension of bodily harm. For example, pointing an unloaded gun at a person may constitute an assault. However, where a defendant utters threatening words to a person, unaccompanied by any such act, that sort of conduct generally is not sufficient to constitute assault. And third, the Commonwealth must demonstrate that as the result of the threatened conduct, the alleged victim did in fact experience a reasonable fear of immediate physical harm. Finally, similar to the first type of assault, the Commonwealth does not have to demonstrate that the defendant had the actual ability at the time of the alleged assault to carry out the threat. Again, apparent ability will suffice. Now, the second element the Commonwealth must prove beyond a reasonable doubt is that the defendant possessed a specific or actual intent to kill the person assaulted. And here again, as I've explained, intent refers to a person's objectives or purposes, and by this I mean the defendant must have had it in his mind to do the prescribed act. Intent involves concentrating or focusing the mind for some perceptible period. Again, it is a conscious act with the determination of the mind to do the act, and it is contemplation rather than reflex, and the intent, the specific intent, must precede the act. Here, the defendant must have specifically intended to kill Aquilino Freire as alleged in count 3, and Gerson Lopes as alleged in count 4, and Rachides Gomes Sanchez as alleged in count 5. This means the defendant must have been shown to possess the actual subjective intent to kill. An intent merely to disable or scare off another is not sufficient intent. The intent to inflict bodily injury or to do serious bodily harm is also not sufficient. Specific intent to kill is a matter of fact that may or may not be proved by direct evidence, and if it's not proven by direct evidence, then you, the jury, in your role as find as a fact, may or may not infer the specific intent to kill from the defendant's conduct. You may consider all the surrounding facts and circumstances and weigh them in light of your common knowledge and experience to determine whether to draw the inference that the defendant committed the assault with the specific intent to kill. And in considering the defendant's specific intent, again, you may consider any credible evidence about the defendant's consumption of alcohol and or drugs, and you may consider evidence of the effect of any ingestion of alcohol or drugs on the defendant at the time of the crime in determining whether the Commonwealth has proved a specific intent to kill beyond a reasonable doubt. However, if you're satisfied beyond a reasonable doubt that the defendant had the specific intent to kill, then the defendant's intoxication, if any, is not an excuse or justification for his actions. Now, the third element requires proof that the defendant, in committing the alleged assault, used a dangerous weapon. And as I've explained, a dangerous weapon is any instrument that by its nature or construction or manner of use is capable of causing grievous bodily harm, injury, or death, or could be perceived by a reasonable person as capable of causing such injury. And again, I instruct you as a matter of law, a firearm is a dangerous weapon. Therefore, if after considering all the evidence, you determine the Commonwealth has proved beyond a reasonable doubt each of the elements I have just defined, that is, that the defendant assaulted the alleged named victim, that the defendant possessed the specific or actual intent to kill that person, and that the defendant was armed with a dangerous weapon, to wit a firearm, then you shall find the defendant guilty of armed assault with intent to murder. However, if the Commonwealth fails to prove any one of these elements beyond a reasonable doubt, you shall find the defendant not guilty of this offense. The next charge is the crime of assault and battery by means of a dangerous weapon in violation of our general laws, Chapter 265, Section 15A, which reads in part, whoever commits an assault and battery upon another by means of a dangerous weapon shall be punished. In order to prove assault and battery by means of a dangerous weapon, the Commonwealth must prove three elements beyond a reasonable doubt. First, that the defendant touched the person of Aquilino Ferrier, however slightly, without having any right or excuse for doing so. Second, that the defendant intended to touch Mr. Ferrier. And third, that the touching was with a dangerous weapon. The first element the Commonwealth must prove beyond a reasonable doubt is that the defendant touched Mr. Ferrier without right or excuse. And a touching may occur directly, such as reaching out and punching or pushing someone, or it may be indirect, such as using a weapon or object to physically touch and come into contact with another person. The second and third elements the Commonwealth must prove beyond a reasonable doubt are that the defendant intended to touch Mr. Ferrier with a dangerous weapon, in the sense that the defendant consciously and deliberately intended the touching to occur, and that the touching was not merely accidental or negligent. The Commonwealth is not required to prove that the defendant specifically intended to cause injury to the victim. It is not necessary for the Commonwealth to prove that the defendant actually caused injury to Mr. Ferrier with a dangerous weapon. Any slight touching is sufficient as long as it was done with a dangerous weapon. And understand, again, intent refers to a person's objectives or purposes, and by this I mean the defendant must have had it in his mind to do the prescribed act, that is, the touching. Intent, again, involves concentrating or focusing the mind for some perceptible period and is a conscious act with determination of the mind to do the act, and is contemplation rather than reflex, and that intent must precede the act. And the third element is that the Commonwealth must prove beyond a reasonable doubt that the defendant committed the assault and battery by means of a dangerous weapon, and as I've told you, a dangerous weapon is an item or object by construction or design or by intended use that is capable of causing death or serious bodily harm, and again that a firearm is a dangerous weapon as a matter of law. Now, if you find that the Commonwealth has proved each of these elements that I've just defined, that is, that the defendant touched Mr. Ferrier without any right or excuse, that that touching was intentional, and that the touching was done with a dangerous weapon, then you shall find the defendant guilty of this offense. If, however, the Commonwealth has failed to prove beyond a reasonable doubt any one of these elements, then you shall find the defendant not guilty. The next charge that you will consider is the offense of unlawful possession of a firearm under count 7 of the indictment. And this charge relates to the defendant's alleged possession of a .38 caliber revolver on July 16, 2012. And you cannot return a verdict of guilty on this offense unless you agree unanimously that the defendant in fact possessed that weapon on that particular date. Again, the .38 caliber revolver being possessed on July 16, 2012, and not any other weapon you may have heard described. Now, in order to prove the defendant guilty of this offense, the Commonwealth must prove 3 elements beyond a reasonable doubt. First, that the defendant possessed a firearm when he was not in his residence or place of business. Second, that what the defendant possessed meets the legal definition of a firearm. And third, that the defendant knew that he possessed a firearm. The first element the Commonwealth must prove beyond a reasonable doubt is that the defendant possessed the firearm when he was not in his residence or place of business. A person who has physical control or power over an object and has the intent to exercise such control is in actual possession of that object. And possession does not depend on the length of time one has the object in his control. Fleeting, even momentary contact with an object may constitute actual possession, and a person need not own an object to have possession of it. The Commonwealth is also required to prove beyond a reasonable doubt that the item possessed by the defendant meets the legal definition of a firearm. And a firearm is defined in our law as, quote, a pistol, revolver, or other weapon, loaded or unloaded, from which a shot or bullet can be discharged, and the length of whose barrel is less than 16 inches. And that definition can be broken down into 3 requirements. First, it must be a weapon. Second, it must be capable of discharging a shot or bullet. And third, it must have a barrel length of less than 16 inches. And the term barrel length refers to that portion of the firearm through which a shot or bullet is driven, guided, or stabilized, and includes the chamber. The Commonwealth must also prove beyond a reasonable doubt that the defendant knew that he possessed this item, and also knew that it was a firearm within the common meaning of that term. And if it was a conventional firearm with all its obvious dangers, the Commonwealth is not required to prove the defendant knew that it meant the legal definition of a firearm. Therefore, if after consideration of all the evidence, the Commonwealth has proved each and every element of this offense beyond a reasonable doubt, then you should find the defendant guilty of unlawful possession of a firearm. If, however, after your consideration of all the evidence, you find the Commonwealth has not proved beyond a reasonable doubt any one of these elements, then you shall find the defendant not guilty of this offense. The last charge relates to a separate indictment charging the defendant with the crime of intimidating a witness or person furnishing information in connection with criminal proceedings. And this charge arises out of the alleged shooting of Alexander Bradley in Florida on February 13, 2013. The term witness intimidation encompasses a broad array of conduct that is prescribed by our general laws in Chapter 268, Section 13b. As pertinent to the instant charge, that statute provides in part whoever, directly or indirectly, willfully threatens or attempts or causes physical injury, emotional injury, economic injury, or property damage to another person who is a witness or potential witness at any stage of a criminal investigation, grand jury proceeding, trial, or other criminal proceeding of any type, or is a person who is aware of information, records, documents, or objects that relate to a violation of a criminal statute, with the intent to impede, obstruct, delay, harm, punish, or otherwise interfere thereby, or do so with reckless disregard, with such a proceeding shall be punished. In order to prove the defendant guilty of this offense, the Commonwealth must prove three elements beyond a reasonable doubt. First, that the defendant, directly or indirectly, willfully threatened or attempted or caused physical injury to Alexander Bradley. Second, that Alexander Bradley was either a witness or potential witness at any stage of a criminal investigation, grand jury proceeding, trial, or other criminal proceeding of any type, or a person aware of information, records, documents, or objects that relate to a violation of a criminal statute. And third, that the defendant did so with the specific intent to impede, obstruct, delay, harm, punish, or otherwise interfere with a criminal proceeding. The first element the Commonwealth must prove beyond a reasonable doubt is that the defendant threatened, caused, or attempted to cause physical injury to Alexander Bradley. In the context of this charge, the Commonwealth must satisfy you beyond a reasonable doubt that the defendant shot Alexander Bradley on February 13, 2013. The second element requires the Commonwealth to prove that Alexander Bradley was a witness or potential witness to some criminal investigation or proceeding in the Commonwealth. The Commonwealth does not have to prove that Bradley had actually provided information to the police or to prosecutors at the time of the physical injury, so long as it proves beyond a reasonable doubt that Bradley was a witness or a potential witness in a criminal investigation. And the third element requires the Commonwealth to prove beyond a reasonable doubt that the defendant's conduct in injuring or attempting to injure Alexander Bradley was committed with the specific intent to impede, obstruct, delay, or otherwise interfere with a criminal investigation. This requires that the Commonwealth prove that the defendant's purpose in shooting Alexander Bradley was to prevent him from providing information to law enforcement regarding the shooting deaths of Daniel De Abreu and Safiro Furtado. The defendant must have specifically intended to impede, to obstruct, delay, or otherwise interfere with the Boston homicide investigation by shooting Bradley. And the instructions that I've given previously regarding specific intent fully apply here. Now, if the Commonwealth proves that the defendant shot Mr. Bradley in Florida, but fails to prove that he did so with the intent to interfere with the Boston homicide investigation, then it will not have proved the crime of witness intimidation, and your verdict would be not guilty. Similarly, if the Commonwealth fails to prove either one of the first two elements, then you must return a verdict of not guilty on this offense. If, however, the Commonwealth proves each of these three elements as I've defined them beyond a reasonable doubt, then you shall find the defendant guilty of this offense. All right, we're in the home stretch. That completes my instructions of law, and let me turn now to talk briefly about your deliberations. It is required in a criminal case, in order for you to return a verdict, that your decision be by a unanimous verdict of all jurors. You cannot return a verdict for either the Commonwealth or the defendant unless and until you have also agreed as to what that verdict or verdict should be. And as I said earlier, you should treat each charge separately, and your verdict must be unanimous as to each charge. It need not be the same verdict. For instance, you might find the defendant not guilty of some, but guilty of other charges, or not guilty of all, or guilty of all charges. But, as I said, it must be unanimous. Now, at this stage, I'm going to select a foreperson for this jury. And the foreperson is sometimes considered as the first among equals. He or she is responsible for organizing the jury's deliberations, for communicating with the court if necessary during deliberations, and for speaking on behalf of the jury in returning your verdicts at the conclusion of your deliberations. The foreperson, however, has no greater say or vote during your deliberations, and in that sense is exactly equal to all other jurors. I'm going to ask juror in seat number 15, Lindsay Stringer, if you would serve as the foreperson of this jury. Yes. Thank you. I'm not sure I was giving you a choice, but I'm delighted we agree. Now, as I stated on the first day, each of you appeared for jury service, and I've repeated at times throughout the course of this trial, you must decide this case based solely on the facts found from the evidence presented during this trial and the reasonable inferences drawn from the evidence. And you cannot consider or be influenced by any extraneous matter or any extraneous information. And extraneous information is any information regarding this case or this defendant that was not part of the evidence presented by way of testimony or through exhibits. During deliberations, you may discuss only the evidence you have heard in this courtroom during this trial, and no juror may reference or introduce information that they know or think they know from any other sources, nor may any juror be influenced by such information. Madam Forelady, if during the course of deliberations there is any reference to or introduction of extraneous material or information, I order that you suspend deliberations and notify me immediately by sending a note so that I may consider and address the issue appropriately. Now, the final function that must be performed is the selection of 3 alternate jurors. The deliberating jury consists of 12 in number, and through the course of this trial, we have had 15 jurors impaneled as a safeguard in case some juror, for whatever reason, had to be excused, either during trial or during deliberations. And at this stage of the case, 3 of you will be selected by luck of the draw to serve as alternates, and you will be kept separate and apart from the deliberating jury during the course of deliberations. And if there is any need to replace a juror during deliberations, one of the alternates would become that replacement. I'm going to now ask Mr. Sheehan to draw 3 names, excluding our 4-person, to serve as the alternates in this case.
Your Honor, may the jury be reduced to 12 members?
Please.
The time having come for the final submission of this case to the jury and a panel of 15 members present, at this time I shall now place the names of each of the jurors in the barrel, with the exception of the 4-person. I will then randomly draw the names of 3 jurors. Those jurors will be designated as alternate jurors. You'll be kept separate and apart from the deliberating jury and in the custody of the court officers until further order of court. Juror number 264, sitting in seat number 12. Juror number 80, sitting in seat number 5. And juror number 69, sitting in seat number 4. Each of you have been designated alternate jurors. You will be kept separate and apart from the deliberating jury and in the custody of the court officers until further order of court.
All right, ladies and gentlemen, I'm going to suspend my instructions now. Tomorrow morning, I will explain to you the verdict slips to be used, and we will have the exhibits ready to be sent up to you, and the 12 deliberating jurors may then commence their deliberations. Please understand that jurors can deliberate only when all are assembled and sent up as a group to deliberate. You cannot have private conversations among select jurors. You can only discuss this case during your deliberations as a group. That's a way of saying between now and tomorrow morning, I again impose the cone of silence on all of you, both deliberating and alternate jurors. Please don't discuss this case. Don't read, hear, or see anything about this case, and don't attempt to learn anything about this case on your own or outside of court. We will adjourn now until tomorrow morning at 9 a.m. for the final portion of these instructions.